A Missouri woman and her neighbor turned boyfriend are now behind bars accused in a case of child exploitation and abuse. According to police, 27-year-old Brandy Hobson is charged with grooming and sexually assaulting a boy under the age of 14. Her boyfriend, 42-year-old Joshua Baker, is also under arrest. Authorities say Baker knew Hobson was abusing the child and never reported it. Instead, investigators claim Baker confronted the boy and physically assaulted him, allegedly driven by jealousy after discovering what happened. I'm Kennedi Walker, and I'll walk you through the details of the allegations. For this story, we go to Pattonsburg, Missouri, about an hour north of Kansas City. It's here that authorities say a boy under the age of 14 endured months of sexual abuse and physical assault. According to the Davis County Sheriff's Office, the reported abuse took place between January and March of this year. The alleged victim lived next door to Brandy Hobson. Redacted court documents indicate that the victim was allegedly the son of Joshua Baker, Hobson's neighbor who later became her boyfriend. A probable cause affidavit reveals Hobson was left in charge of the boy and his sibling on several occasions. On January 10th, Hobson allegedly picked the child up for a weekend stay with Baker. It was then that investigators alleged that Hobson began grooming the child and forcing him into sexual acts. Detectives say on one occasion, Hobson touched the child's genitals over his clothing, then placed his hand on her breast and kissed him. The very next night, authorities allege Hobson invited the boy to sleep in her bed for further sexual contact. According to prosecutors, the abuse continued repeatedly until March. Court documents say Hobson allegedly told the minor that they would have a public relationship when he turned 18, but at the time, the child was reportedly years younger. Investigators say the abuse ended after Joshua Baker allegedly assaulted the child out of jealousy. According to the sheriff's office, Baker discovered the inappropriate relationship back in January. But instead of alerting authorities, Baker allegedly confronted the child privately and chose not to report the abuse. Detectives say Baker told Hobson he would keep quiet under one condition. She would end the relationship with the child and start one with him instead. Documents show that after learning of the alleged abuse, Baker still allowed the boy to be around Hobson. That continued until March 9th when, according to law enforcement officials, tensions came to a head. On that day, Baker allegedly confronted the boy again about the sexual contact with Hobson. Investigators say Baker swept the child's legs out from under him, threw him to the ground, and headbutted him. Baker was arrested and charged with child endangerment, child abuse, and domestic assault. Hobson now faces 4 counts of molestation of a child under the age of 14, 2 counts of endangering the welfare of a child, and a single count of enticement of a child. And joining me to talk more about this is criminal defense attorney Eric Bamer. Eric, thank you so much for coming on today. Let's just jump right in. How strong
Okay.
does the evidence appear based on what we saw in the probable cause statement?
Well, the evidence looks very strong, but it's hard to know at this point in time because that's the very nature of a probable cause statement. It's made to look very strong. They make it so that charges will be filed, and they're always one-sided. So you just don't know what to expect yet. But yes, when you read that statement, it looks like a very good case.
How many years are both suspects facing?
I believe the one was like 54, maybe somewhere in the 50s, and the other one was maybe a little bit less. But I mean, at their age, it could be close to, especially the older person, close to the rest of their life.
Wow, decades. That's a lot. So could these defendants face any federal charges in addition to the state charges?
They could, and sometimes I would say more likely that they will. You know, when you get the obscure, the really weird and bizarre cases, a lot of times the federal government likes to step in and pick them up to make an example. And that's bad news because if they take care of this case first on the state level and then the federal case gets picked up, it's counted as a prior and it hurts their numbers. So they will get a significantly larger sentence in federal court.
Can you explain that? So, for example, if one of them is facing 50 years in state prison and let's say they get convicted, so then federal, they can come in and say, oh, we want 20 more. Like, how does that work?
Well, so the way it works is assuming that right now they don't have any criminal history and they're charged with this case on the state level, and then they charge them later on the federal level. Now, it's a little interesting to think about, well, this is the same thing, right? Well, not exactly. If they were to plead guilty at the state level, say they worked out a plea bargain, they only got 25 years, they pled guilty. Then the federal government comes down and files charges. They count that state plea as a prior, even though it's the same case. So they work on a point system in federal court. So that will elevate the potential amount of months that they have to serve on the federal case. So it will more likely make that sentence more harsh than it would have could have been because they count as a prior.
And Brandy Hobson, she's accused of grooming the minor. For those that don't know, can you explain what that means?
So essentially, when they talk about grooming, it means that you're someone that's trusted, someone that you know, and you spend time gaining their confidence, getting them to trust you and believe you, and then use your power and authority, so to speak, over this person to then take advantage of them. It's usually a process that can take anywhere from weeks to months, sometimes years.
And how serious is the charge of child endangerment compared to the molestation charges?
Child endangerment is a much more minor charge. If I have a client who's got a situation like this, I tell them you don't need to worry about the child endangering. The other one is the big deal. Child endangering is often a kind of a release for us if we have a child. In the defense world, if you have a child abuse case, something more serious, but the case is maybe triable. Maybe you have some evidence on your side. The go-to middle ground is usually child endangerment. So that one is not as consequential compared to the heavier cases charges that they've got.
How does Missouri law handle cases where both sexual abuse and physical abuse are involved?
Well, usually they'll go with the harsher of the two, and it's usually the sexual abuse. They could file separate counts because there's the statutes allow specific charges just for sexual abuse, and they allow specific charges just for physical abuse. And often they'll use just the sexual because for jury appeal, it's much more damning. It's much more difficult to win for a defendant, and often the penalty range is much higher on the sexual abuse.
Will Joshua Baker's alleged confession to knowing about the abuse strengthen the state's case? I would assume.
I would think so. Yeah, I mean, it obviously gets him in some hot water too. I mean, you get a case like this, you've got neglect, you've got child services issues, you've got criminal issues. There's a whole lot of people that could be coming after him for this. But as far as you have to look at a case from jury appeal, or if you work out a deal or you plead guilty, from judge appeal. And when you have someone who's deciding your fate, whether it's a jury, whether it's a judge, whether it's sentencing, and just in front of the judge, you know, it's common sense. These are people also, and as appalling as it sounds to you, a judge is going to be the same way. I mean, it sounds bad.
What kind of defense might, Hobson and Baker's attorneys use in a case like this? If you were defending them, let's first start with Hobson. How would you defend her?
The problem is we don't know enough yet, right? This was the question I was most concerned about that might come from you because it's so hard to answer. You know, my defense often doesn't pop up for 6 months to a year in a case where it finally reveals itself. The initial report is usually brought in. It's an investigation done. They want to get charges filed right away, so they turn it in to get these people behind bars because they're a danger to the community, maybe a flight risk. But the investigation may not be over. There may be more interviews to be had. There may be more things that come out down the road that might hurt the case or might help the case. So you don't really know where you're going to go from a defense standpoint until you get deeper into it. Plus, I need to talk to the client. I need to talk to them and find out what their side of it is, and do you have alibis? Are there other people that we could talk to say, well, this is just crazy? But when it's he said, she said, you've always got a fighting chance.
And what about the father or Baker? What about Baker? How exactly, and I know you said, we have to wait for more to come out, but how could you argue this at all if you're him? Could he argue that, hey, I'm not accused of these things. I'm just accused of the abuse, the physical abuse.
Well, if I'm representing him, that's exactly how I try to spin it. It's like, well, look, I'm not the big fish here. The big fish is, the co-defendant here. And, I know some stuff about her case. Perhaps we could talk about that. Perhaps you could be using my testimony. Maybe I could be of assistance to you. And in the meantime, help myself out a little bit along the way. That might be how I approach it, not knowing what's going to come of it down the road, that the full investigation. But my first thought is he's a guy that might be able to help himself out by helping the state with their case.
Could Hobson's attorney argue that she didn't know the boy's age, or that doesn't really matter legally, right? And it's hard to believe, if this did happen, that she didn't know his age?
Well, if the victim is under 14, then the age doesn't really matter. Yeah, there's no defense for mistaken age if they're under 14.
Right. And so going back to Baker, could he argue that he didn't report the, alleged abuse because maybe he didn't believe the minor? Would that be a viable defense?
It would be. Yeah, I would think that um, credibility could come in. He's not a mandatory reporter, I wouldn't assume. So that would be one issue that might help him out. And he could say, well, yes, the child told me so many conflicting stories, I just didn't believe it. Or it sounds so crazy that I thought it was just a story he was telling. So, yeah, I mean, there's ways to spin it to try and make it look like a defense. But I don't know. I mean, maybe they've got text messages, where he made some admissions or where she made admissions to him. So, hard to say what could pop out of that might be bad for him.
We touched about this a little bit earlier when you said, making sure, one may say this, the other may say that. How common is it for co-defendants to turn on each other in child abuse cases?
Well, it depends on the relationship. Married couples who were not on the fence to begin with will tend to stick together. I'm dealing with a homicide case right now of a child, infant, that is an involuntary manslaughter, and both couples stuck by each other's side, and we're going to work out a good disposition because of that. But I would say it's also relatively common that, self preservation kicks in and they start turning on each other. It just depends on the solidness of the relationship, typically. And if one party is more to blame than the other, it might, end up really upsetting the other parent or the other part of the couple that their child was really hurt. So to answer the question, it may be 50-50 on that.
If convicted, would Hobson or Baker have to register as sex offenders?
Uh, Hobson for sure would. Baker, I don't believe he would have to, based on his charges, if I remember correctly. I don't think he had sexual related charges. I think his were just abuse, so he would not have to. There are abuse and neglect registries that he'll probably be placed on. That's a civil process, but not registering as a sex offender like she would.
Could either, if they are convicted, could either defendant be eligible for parole? If so, when? How would that go?
So the parole board has certain guidelines. Obviously, when you're sentenced to something, it's always a possibility you could serve your entire term. But there are guidelines for parole, and they're usually based on percentages. And it's anywhere as low as 10 to 15% for simple drug cases, and as high as 85% for certain Class A felonies. I do believe that um, some of her charges would require an 85% sentence, but most of the charges I saw in there would be more in the 50 to 60% range.
What resources are available to the victim and any siblings in a case like this?
So there is a crimes victim compensation, which is one thing that the state provides to help with financials. The issue on this case is a little bit different because you're dealing with minors. So they would probably be taken into the juvenile system and found, suitable foster, whether it's a relative or a stranger, depends on the family dynamic. But they do provide some funding and housing for them, like I said, in the foster system. But the foster system doesn't always mean you're going to some strange house. It might be you've got an aunt somewhere who's been cleared from her background check and is capable of taking the child. They will get supplement from the judicial system to support food and clothing and stuff like that. So there are resources to help with the children.
Do you think the victim will testify?
Normally what happens in a case like this is they will take the child to do what's called a CAC. It's a child advocacy center interview, and it's secretive, and they'll have a professional interview them. They'll be supervised behind a two-way mirror by law enforcement, and they'll get them to speak for maybe an hour or so and divulge all the things that happen. In Missouri, when the child is under a certain age, that video can be used in the trial. Now, it does require, in the criminal case, for the victim to also testify, but it provides the state a great tool if the victim gets nervous and doesn't necessarily do that great of a job. They are subject to cross examination, but the state, if they'll have a hearing to determine whether or not they can use the video, and they usually can, they'll be able to provide this video and show it. And it's a very damning tool for the state. So uh, they would be required to testify and use the video, but most of the time, if the video is really good, it's also a preventative tool to keep the case from going to trial, which would keep the child from having to testify.
How does a case like this impact future custody or parental rights if Baker is the boy's legal guardian?
Typically the juvenile department, they've gotten involved now, right? They've gotten involved with probably taking custody of the child. They have to file formal actions, and that formal action would usually be against the legal guardians or the parents, if it's these two individuals, to take custody away from them. It usually in the beginning it's just physical custody, but I would assume they would move for a full termination of parental rights with the court. So that's usually what happens in a case like this. It's so egregious, they're not going to try and reunify the parent and the child. They're just going to move to terminate the parental rights and let the adoption process open up.
And just speaking of egregious, just tell me, how difficult is it to seat an impartial jury in such an emotionally charged case?
It is almost impossible. When you one of the hardest cases that there are, especially for her, one of the hardest cases that there are to try and separate a jury from emotion and just stick to facts is a sex case. And when you sprinkle in the fact that it's a juvenile and a sex case, it's very difficult to separate the emotion. I had a trial one time, and we had a juror who wasn't speaking very much. And keep in mind, during jury selection, the prosecutor, the judge, and then the defense attorney go over with the jury for quite a bit of time how the defendant is innocent as they sit here today. And I won't go over it all with you right now, but you elaborate quite a bit. They're innocent as they sit here today. And I had this juror, as we I started asking her questions because she didn't say much, and she blurts out, after what he did to this girl, so on and so forth. And she just heard the three people in the courtroom talk to her, lecture her in the group about how he's innocent as he sits here today. Just goes to show you, you can say a lot of things in that courtroom, but those preconceived emotions and ideas, they're hard to purge.
So, for the prosecution, during the trial, I'm expecting that they're going to be bringing all types of expert witnesses. Who do we expect to see in a case like this? What kind of expert witnesses might prosecutors call during a trial?
Well, most of the time in a case like this, they will take the child to a specialized doctor and have them do maybe a rape kit or some other sort of a physical examination. They often have what's called a sane nurse do a sane exam, and they check for any potential previous sexual activity, and that person would be one of their biggest weapons to come in. And any other doctors or psychologists that they might be seeing about this, but that's the number one weapon for them, is this doctor or nurse who does this sane exam to determine whether there's any sexual contact.
And I have to ask you this question before I let you go. What message, if any, does the prosecution of this case send to other potential mandatory reporters?
Well, I think that for a prosecution, most of the time, attorneys and prosecutors, you don't really want to mess with the media too much on the day to day because you've got so many cases to handle. But there are certain types of cases that you want to get out in the public. And that's why they do the news releases. They want deterrence. They want to see that people who think that they are behind closed doors doing weird or crazy stuff, who think they're never going to get caught, they want those people to see someone just like them get caught. And they want to see someone just like them get a severe penalty for it. So that just maybe they can save a few victims out there, and change a few minds on some potential defendants.
Well, this is a case that we will be following closely. Eric, thank you so much for joining me today.
Oh, you're very welcome. Thank you for having me. I enjoyed it.
As of this recording, no bond has been listed for either suspect. During the investigation, it was also revealed that Hobson allegedly admitted to previously being in an intimate relationship with an inmate while she worked at the Davis-DeKalb County Regional Jail. For Law and Crime, I'm Kennedi Walker.